Welcome to the Ameri Rush, where America moves fast.
Over the past few days, the U.S. immigration system has gone through another wave of important changes. Courts have stepped in to block some of the Trump administration's toughest moves on rapid deportations. A federal judge has restored critical protections for vulnerable immigrant youth. USCIS has announced new fee increases that will hit many families and employers from January 1st, and the Supreme Court has agreed to hear a major case on how asylum seekers are treated at the southern border. At the same time, there is fresh movement in the December 2025 Visa Bulletin, and immigrants are trying to understand what all of this means for their green cards, visas, deportation risks, and processing timelines in the months ahead. In this video, we'll calmly walk through this week's biggest immigration developments, from new court rulings and Supreme Court action to USCIS fee changes, protections for young immigrants, and what the latest Visa Bulletin tells us about green card movement going into 2026. Now let's get into the video. This week's first major headline comes from Washington, where USCIS has formally announced that certain immigration-related fees will increase starting January 1st, 2026. These changes are inflation adjustments required under H.R. 1, and DHS has published them in the Federal Register. For any covered benefit request postmarked on or after January 1st without the updated fee, USCIS will reject the filing, which means applicants and attorneys now have a clear deadline to adjust their payment amounts and filing plans. News outlets in India and elsewhere have already highlighted that this will raise costs for a wide range of immigrants, including those applying for H-1B visas, green cards, and related benefits, particularly from high-demand countries like India. Families sponsoring relatives and companies sponsoring workers will need to budget for higher filing costs in the new year. At the same time, the Trump administration faced a significant legal setback on deportation policy. A federal appeals court in Washington, D.C. refused to clear the way for the administration to dramatically expand expedited removal, the fast-track deportation process. The administration had sought the power to use this rapid deportation tool against migrants found anywhere in the United States who could not quickly prove they had been in the country for at least 2 years, instead of limiting it mainly to those near the border. The court agreed with a lower judge that this expansion risked violating migrants' due process rights under the U.S. Constitution, and largely left the block in place. For many immigrants and advocates, this ruling is a rare piece of good news in an environment of increasingly tough enforcement. It means the administration cannot, at least for now, widen rapid deportations into the interior of the country as aggressively as it wanted to, and people who have been living inside the U.S. for some time maintain stronger procedural protections if they are picked up by immigration authorities. Another big development this week came from a federal court in New York. U.S. District Judge Eric Comity ordered USCIS to reinstate a policy that automatically considers certain vulnerable immigrant youth for deferred action and work authorization when they have been granted special immigrant juvenile status, known as SIJS. The administration had ended this protection earlier in 2025, leaving many young people who had already been recognized as abused, abandoned, or neglected at risk of deportation, while they waited for long backlogged visas to become available. With this new order, USCIS must once again consider deferred action and work permits for these youth, including both those who already applied and new applicants going forward, at least while the lawsuit continues. For children and young adults who had been living with constant fear of removal, despite having SIJS, this is a crucial protection and one of the most meaningful court wins of the week. There were also important developments around citizenship and voting. USCIS recently attracted criticism after halting naturalization ceremonies in several New York counties, but under intense public and political pressure, the agency reversed course and agreed to restore ceremonies in places such as Westchester, Rockland, and Schenectady. Local officials and advocates had warned that the cancellations were creating unfair barriers for eligible residents who had completed every step of the process and were only waiting for their oath of allegiance. At the same time, a separate battle is unfolding in federal court over the Trump administration's policy banning voter registration activities at many administrative naturalization ceremonies. The League of Women Voters has filed a lawsuit arguing that stopping nonprofits from helping new citizens register right after they take the oath is a form of voter suppression and violates both the Administrative Procedure Act and the First Amendment. The administration defends the policy as part of its broader immigration and election reforms, but the outcome of this case could significantly change the experience of new citizens at future ceremonies. On the Supreme Court front, there was a major update this week that affects asylum seekers, even if its full impact will not be felt until 2026. The court has agreed to review the legality of the border metering or turnback policy that was used in past years to limit the number of asylum seekers allowed to present themselves at official border crossings. Under that system, U.S. officials told people to wait in Mexico rather than letting them physically approach ports of entry even when they were trying to request protection. A federal appeals court had previously ruled that asylum seekers who reach ports of entry are considered arriving in the United States and should be allowed to apply for asylum. Now the Supreme Court will revisit that question. Arguments are expected in early 2026, with a decision by June. This case does not change today's rules at the border, but it signals that the highest court is once again stepping into core questions about who can seek protection and how far the government can go in turning people away. For families and individuals who have been trapped in dangerous conditions waiting just outside the United States, the court's eventual decision could shape whether similar policies can be used in the future. Now let's look briefly at what is happening with green card movement and processing timelines. The December 2025 Visa Bulletin has been released, and there is some modest good news on the employment-based side. For Indian applicants, several categories including EB1 and EB2 have moved forward, bringing cutoff dates slightly closer and offering a bit more hope to those stuck in very long queues. However, many family-based categories remain largely unchanged, which means spouses, parents, and siblings in the preference categories are still facing long waits. USCIS has also updated its guidance on which Visa Bulletin chart applicants should use when filing adjustment of status applications inside the United States. For November and December, the agency continues to instruct applicants to check its When to File and Adjustment of Status Filing Charts pages to see whether they must rely on final action dates or the filing dates chart, which can affect when a person becomes eligible to file for a green card from inside the country. Processing time data coming from law firm tracking and USCIS information suggests that many family-based adjustment of status cases are still taking close to a year from filing to decision at several field offices, with some local variation. That means that even though there is some movement in the Visa Bulletin, and the agencies are trying to stabilize operations after earlier fee and system changes, applicants must still be prepared for months of waiting after they submit a complete package. Meanwhile, USCIS continues to implement earlier announcements that expanded premium processing and streamlined certain employment petition workflows, including some H-1B and temporary worker petitions, in an effort to provide more predictability for employers and workers, even as the broader system remains under strain. When you put all of this together, this week's immigration picture is complex but clear in one way. The system is being pulled in two directions. On one side, the Trump administration is still pushing for tougher enforcement, fee increases, tighter control over who can stay, and limits on how advocacy groups can support new citizens. On the other side, federal courts and the Supreme Court are stepping in to set boundaries, blocking the expansion of rapid deportations without due process, restoring protections for abused and neglected immigrant youth, and agreeing to review how asylum seekers are treated at the border. For families, workers, and students watching all of this, it can feel overwhelming. But understanding these developments week by week helps you see where things are actually changing and where your own case might be affected. If you are planning to file in early 2026, you need to keep the new fee schedule in mind. If you or your children are in SIJs or other vulnerable categories, the recent court order may offer new protection. If you are part of a community near the border or have loved ones waiting in Mexico, the Supreme Court's upcoming case will be important to follow. As always, staying informed, keeping your documents complete, checking official USCIS and Department of State updates, and talking to a qualified immigration professional when needed are the best steps you can take in a fast-moving environment like this. That's all we have for this bulletin. Thank you for watching, and we'll see you in the next video.
Subscribe, like, share, that's free and go!